Hey guys, this is Bala. Hope you all doing well. Today I would like to talk about the due process and what is the Fifth Amendment and 14th Amendment in simple ways. So, what is due process? Due process in simple terms says that must all people persons must respect all legal rights that are owed by the person. So you have to respect all the rights that regarding to that person. So Fifth Amendment says in simple terms that U.S. Constitution have says that no person shall be compelled in any criminal case to be against himself. So and also I would like to talk about the 14th Amendment. In simple words, it says that equal protection of the laws. So and regarding this, I pick some cases, and now I would like to talk about those cases regarding 14th and fifth amendments. So we're coming to the 14th amendment. So it was happened in the general hospital, and then the issue is minimum necessity and private communication. So the issue mainly rises between the communication. So the amendment says that the hospital impelled a new minimum necessary rule concerned with the telephone messages. So when it comes to the case, a hospital worker filed to discredit the minimum necessary policy after she left a phone to the text message with the patient's daughter, containing her details outlined to the patient treatment plan and medical conditions. So as investigations say done by the OCR, so revealed that the confidential communication needs were not met because the employee sends the message to the patient's home telephone number. However, the patient had instructed to the employee to contact her through the work number, not in order to eliminate the issue to the hospital, and drafted and implemented various new methods or steps. So the minimum necessary was addressed in this issue is the employee was trained and agreed to refresh the training annually. So that's the case. So and I would like to talk about some cases in the Ninth Amendment. So Supreme Court decided Ninth Amendment after 1965, and the High Court had reached the decision of striking down a particular state, rejecting the reliance of contraceptive methods because the law was violated the privacy of marital confidentiality and a privacy. The case resolved that since the marital privacy was protected by the shadows of the Fifth and Fourth and Third and Second Amendments, and also covered in the Ninth Amendment. So and now I would like to talk about HMO versus OCR. So the case scenario is the covered entity is health plans. So this case was regarding the health plans, and the case scenario is the complaint argued out the HMO willingly revealed out members patient of health information, and after sharing the information to the medical insurance provider without any acquiring the patient's consent and the authorization. So although the investigations could not conducted by the OCR, the OCR is an electrical method where you can transfer the files, all your data to an we can that can be editable. I mean, we can edit whatever the files we did, that we can, for example, PDF, we cannot edit anything in the PDF file. So that files we can edit in the OCR. So that's a new technique. So and found out that the form used on HMO is visualize the patient's health information. The insurance company was not legitimately authorized under the privacy policy as a corrective measure of to resolve the issue. The Human Management Organization developed a new HIPAA policy compliance authorization, and enacted a new policy which was advised the staff acquire patient signature has to be done, and authorization before the embarking on the disclosure of activity of the patient's health information. So the process of creating transparency in health insurance administrator as an administrative paved by a way for the digitization of patients' health records. So the specific rule of this ACT is a share amendment of the policy of health information technology, clinical of health and economic act in 2009. So in 2009, it resulted the creation of meaningful of incentive program. The meaningful use of incentive program was reckoned by the healthcare leaders, and most of the vital effective legislation ever made in the healthcare was a period of 3 decades. So, and I would like to take other case, talk about the other case, outpatient hospital center. So notice, issue is notice, and then the involved parties is outpatient hospital centers. So the amendments is mental health hospital amends the process of issuing notice of privacy practices. A certain mental facility failed to issue a notice regarding the privacy practices or in a certain father who had a minor patient within the facility. After being questioned by the OCR, the hospital administration argued out that they had failed to issue a notice to the father or the minor before mental health assessment. In order to resolve the problem, the mental health facility modified its process to intake assessment rule and steps to define whether the notice will be given, and doctors will acquire and signed authorization of receipt of the notice before embarking the assessment and process. The acknowledgement should be included in the intake package of forms in the center gave the OCR written assurance that all the rule was taken with a great concern among the staff. The policy basically outlined that on manager of disclosing the patient's health information is required on the acquired permission from the patient before utilizing the patient's information. So it affects the medical research outstanding and also the funds of the medical payment of marketing. The law also allowed patients the rights of disclosing the healthcare information after being asked by the insurance companies, especially when the treatment is personally frauded. So for the HIPAA scrutiny rule of health electronic records was enacted in April around 2005. The policy dealt particularly the digital store patients' health information. The security policy outlined the main scrutiny measure, physical, technical, administrative components of the electrical health information systems. So and the last obvious rule in 2013, this is the most current legislative amendment performed in 2013. The policy just introduced a new legal provisions of show how harmonize the relationship between high-tech and HIPAA policies. So for instance, the legislation is pinpointed out that exact encryption of standards of to be issued health information networks to make sure that the electronic patient's health information remains, because nowadays the electronic high tech is developing, is a boom of developing in healthcare. So it might be a misuse, and some people are using misusingly. They are sharing their files, the documents to the other companies. So that's a big misuse. So some definitions are changed in to bring clarity. For example, the workforce was changed to reveal out it referred both tradies, employees, volunteers, and other individuals involved in the health professions is covered patient. The security and privacy rules were changed to permit patients' health information, and also always remain non-defined. New penalties were also added in the obvious rule. So they do that. The penalties were also added to their whatever the organization or so. So yeah, and that's all I would like to talk, and hope you all enjoy. Thank you.